Good morning, everyone. Thank you for joining us today. Today, you are here to see the new legal protections for California tenants in the wake of COVID-19 with Jesus Munoz, staff attorney for Bay Area Legal Aid. Before we get started, we want to ask everyone to please put their questions in the question box if any arise throughout the presentation. We will get to them at the end of the presentation and also answer any questions that may pop up at the end. So without further ado, I present to you Jesus Munoz.
Good morning, everyone, and thank you for joining us for this presentation on legal protections in the wake of COVID-19 for California tenants. So we have a few objectives today. So today we will attempt to obtain a general overview of the eviction protections under the Tenant Protection Act of 2019. We will learn about the current eviction and rent protections available to California tenants under the COVID-19 Tenant Relief Act of 2020. And we will also try to acquire an understanding of additional local eviction protections available to tenants in Alameda County under the Alameda County Eviction Moratorium. So I wanted to start off by having a discussion on the protections that were inaugurated in January of 2020 through the Tenant Protection Act. These predated COVID-19. These were protections that were instituted in the wake of the housing crisis in California and the need to sort of fill in the gaps, because in California we were having situations where you had certain local jurisdictions, many, for example, here in the Bay Area, like San Francisco, Oakland, Berkeley, who had very specific just cause eviction protections. But then you would have individuals, people who may not live in areas such as those, who really didn't have any other protections other than just basic due process rights under state law. So the Tenant Protection Act of 2019 was an attempt to fill in those gaps. So it has a few important features. The first feature is that it provides for statewide just cause, meaning that just cause is required for termination of a tenancy, generally of more than 12 months duration. That's assuming that all the tenants have been living there since the beginning and have been living there for at least 12 months. You get into a little more complications if, for example, you have a tenant that's been living there, then all of a sudden someone else is added onto the lease. Unfortunately, we don't have time to sort of discuss that permutation. But in general, if you have a standing tenant that's been there and they or along with their family members have collectively lived in that unit, since the beginning for at least 12 months, after the 12 months are over, assuming that there are no new people coming into the unit as new tenants, after the 12 months conclude, they're entitled to the statewide just cause protections. And we will talk a little bit about what that means in subsequent slides. But the important thing to remember is, unfortunately, yes, there are exceptions, and there is a body of housing that is not covered by the state just cause protection laws. So exempt units that are not covered include dorms, and owner-occupied duplexes where the owner continuously occupies the other duplex as their principal place of residence. Single-family homes that are not owned by a corporation or limited liability corporation. Mobile homes, certain affordable housing shared with the owner, meaning that there's an individual, a single person who lives in the actual single family home with the owner, and they, for example, maybe rent a room in the house and have use of the common areas. That's what's considered to be a lodger. Another type of unit that is exempt, that is not generally covered by this law, is a single family owner occupied property where no more than two bedrooms are rented. Hotels and hospitals are also exempt. So this is a body of housing that is generally not covered under statewide just cause law. Now, one note about these exemptions. So when we're dealing with the situation where you have a non-corporate, non-LLC owner of a single family home that rents out that home to a tenant, This is different from the lodger. We're not talking about the lodger. We're talking about a house that is not occupied at all by the owner, but it's a single family home that is owned by a private owner that is not a corporation. Uh, Now, that owner actually has to inform the tenant in writing that the unit is exempt from state just cause laws in order for them to enjoy that exemption. And if the tenancy began after July 1st, 2020, that notification actually must be included in the lease itself. So that's an important thing to remember. So now let's talk about what constitutes a permissible or a just cause for eviction. So there are two different types of just causes under the state law. So there's the at fault causes, and then there are the no fault causes. So with respect to the at fault causes, where person is being evicted because of what that person as a tenant did or did not do. Uh, the first at fault cause that it's very common for people to be evicted for is non-payment of rent, also nuisance. So for example, if you cause loud noise, excessive noise that disturbs the quiet enjoyment of other residents, if you lay waste to the unit, if you also commit a breach of a term in the lease, that could be considered an at fault reason in order to justify the eviction. Any criminal activity in relation to the unit or the use of the unit for an unlawful purpose. Uh, Refusal to allow the landlord entry for legally authorized reasons. So, for example, to make necessary or emergency repairs. Another possible legal reason for the landlord to enter the unit would be after they properly notify you of a sale of the property. They can, under limited circumstances and under certain guidelines, go into the unit to show it or have that unit shown to prospective buyers. So that's another valid reason for why a landlord could seek the eviction is if the tenant refuses. Now, in the wake of COVID-19, there are certain local restrictions on that, obviously, because you don't necessarily want individuals coming into the unit who you do not know, who are obviously outside of your household. So each individual county has guidelines on that, and I would encourage you all, specifically if one lives in Alameda County, to go to ac.gov, and they have a housing section there where they talk about the particular orders. And I do believe, hopefully, it's still there. I do believe seeing that I saw something on that website regarding what the guidelines are here in Alameda County for showing a unit that's occupied by existing tenants. Um, so assigning or subletting the unit in violation of the lease also can be an at fault reason that would cause the landlord to have just cause to evict. Also, a refusal to sign a new lease or a renewal lease that is materially the same as the prior lease. Uh, the last category in terms of at fault evictions includes the failure to deliver the possession of the unit after a tenant submits a notice to vacate. So the theory there is that you submit a notice to vacate, uh, un- unless there are like extenuating circumstances that provide some sort of exception. The landlord can argue that they've relied on that notice, and you can't just backtrack on it after having provided that. Obviously, each case is going to be different. There might be disability related reasons, uh, but each of those cases will need to be handled based on the particular facts of that case. So, in addition to the at fault bases for eviction, there is also what's called the no fault category. So that means that the tenant may not have done anything wrong at all, or they may not have failed to do something that they were required to do, but nonetheless, under these categories, the owner can still technically evict. So if, for example, the owner wants to move into the unit, that is a category where they may be able to actually evict the existing tenant. Now, there are certain things that need to be complied with, and one of the main things that needs to be complied with, based on my understanding, is that they need to show that they don't really have any other property to which to go. Um, and it is a very specific process. It isn't just, okay, I just want to move in there, because there is obviously the possibility of fraud where the owner might have a claim that they want to move into the unit, but in reality they might have other properties that they technically could move into, but they just want to oust this existing tenant so they can rent it out to someone else. So it's going to be a fact specific inquiry, but in general, assuming it's a good faith claim, there are certain situations in which the owner can evict an existing tenant in order for them to then go ahead and move into that unit. Also, substantial rehabilitation, where if there needs to be repair and the repair is of such magnitude that you cannot have individuals living there while that's being conducted, they might, then cause the tenant to, be evicted or temporarily relocated based on the local regulations on substantial rehabilitation. Red tagging. So that's if the particular city or locality determines that the unit is a health hazard, or it's in such a hazardous condition that no one can live there. That might then also uh, be a reason for a no fault eviction. Uh, Obviously demolition and also removal from the rental market. Again, we don't have too much time to get into this, but there is an act in California called the Ellis Act, where if an owner, under certain circumstances, if they wish to remove the unit entirely from the rental market, there are mechanisms in place that allow them to do that. But it's very complicated, and the owner actually has a burden of complying with a legion requirements. It's not simple at all. But that again, technically is a no fault reason for eviction. Now, there are additional protections under the Tenant Protection Act of 2019, which again went into effect in January of 2020. So there are some relocation benefits. So there's a provision for a 1 month's rent or waiver of the last month's rent if the tenant is experiencing a no-fault eviction. So if it's an owner move-in, a rehabilitation, demolition, red tagging, or removal from the rental market. This relocation benefit must be paid within 15 days of the notice of eviction. Also, an important feature, California, as part of this law, instituted a ban on what is colloquially termed Section 8 discrimination. So previously, under California Fair Housing Law, it had been, and it still is, illegal to discriminate based on source of income, a person's source of income. Now that's different from like a credit history or whatnot. We're talking about where source of income insofar as like a receipt of public benefits. So you can't like deny housing just for that reason. Unfortunately, for the longest time, and it didn't really make sense why, but Section 8, the receipt of Section 8 subsidies did not fit within that definition or was not included in that definition, but the law has since corrected that. So now landlords may not refuse rental applications based on the prospective tenant's receipt of Section 8 housing subsidies. That doesn't mean that a person, it's going to be on a case by case basis, but the way that it's made more clearly manifested is, and I don't know if anyone had access Craigslist, within the past 2 or 3 years, but there were Legion ads that said very clearly in bold, no Section 8. Well, that is prima facie illegal now. And the way discrimination works in our society, unfortunately, is that you don't always know, and no one's going to advertise all the time that they're discriminating, but there are other ways. Like, say for example, you go into a property, you want to submit an application, the landlord asks you, well, do you get Section 8? Do you get like any sort of housing benefits from a housing authority? You say yes. Say, well, let me call you later. And then you don't get called. All other things being equal, that could be an indication that there could be discrimination based on your Section 8 status. So the landlord can, like, if they accept the application, can still deny you for other neutral reasons. So for example, they accept your application, but then another tenant who applied at the same time has a better credit history and better rental history. Then that might be a situation where they might be allowed. But the reason why they're not giving the apartment is not because of your Section 8 status, but rather because they have another prospective tenant that seems in their mind to be more objectively ideal. But again, each case is going to be different, but in general, Section 8 discrimination is barred under law. So I do have a couple of caveats and warnings and things to keep in mind with regards to the Tenant Protection Act. So with regard to local just cause ordinances, there are cities such as Oakland, Berkeley, Hayward, and Alameda that have local just cause ordinances, which offer stronger protections for covered tenants than what state law actually provides. Now, these stronger protections continue to apply to covered tenants in these cities. So the state law again is just a law that generally is used to fill in the gaps, and we do have much stronger protections in many of our Bay Area cities, and obviously those are the ones the stronger protections will generally control. Okay. Now, the other thing, we're going to get into this a little later, but in light of COVID-19, just cause is required now for all evictions until February 1st, 2021, per new state law that is colloquially known as AB 3088. So that means that all tenants are covered regardless of where they live or how long they have rented the unit. And also, no cause evictions at this point in time are not permitted against any tenant. Okay, so that's something to keep in mind, and that's in effect until February 1st, 2021, per the current law. And again, we'll talk a little more about that and what the ramifications of this February 1st date mean a little later. So I want to move us towards a hypothetical so we can sort of try to see how these uh, laws, come into play. So Maida and her family have been living in a unit located in a duplex, which was constructed in 2003. They've been living there for more than 2 years. There is no other tenant living in the other unit, but the owner of the duplex, Mr. Vaughn, uses the neighboring unit as a weekend home. Recent gentrification in Maida's neighborhood has motivated her landlord to try to persuade her to move out so that he can either rent the unit at a higher rate or sell the duplex to a prospective buyer who can offer a lucrative price. Maida has refused to leave as she cannot afford to move further away from her workplace. The landlord thus issued Maida a 60-day eviction notice indicating to her that he needed her to leave as he was placing the property for sale. So, can the landlord evict Maida for the stated reason under state law? Yes, the landlord as a single private landlord is exempt from just cause laws. Yes, as the unit is in a duplex in which the owner occupies the adjacent unit, it is therefore exempt from state just cause laws. Yes, the landlord may justifiably base his desire to sell the duplex as a legal basis to evict. No, state just cause laws apply and would prohibit Mr. Vaughn from evicting Maida and her family for the stated reason. So I'm going to open up a poll here, and I'd like to know. I think people can select only one answer, and wait for a minute for the responses from the participants. Oh, my apologies. I'm going to relaunch the polling. My apologies, because I actually clicked on the wrong question here. My apologies. Let me unclick. This is where I'm going to end the polling. Please ignore the results. Totally my fault. My apologies. Okay, this is a correct one. So, can the landlord evict Maida for the stated reasons under the state law? me give people 10 more seconds. Okay, so it appears that the majority of people picked option number D, and that is actually the correct option. So let me explain. So as we've noted, the fact that the landlord is a single private landlord, that in and of itself does not exempt the landlord from abiding by the state just cause. There has to be a specific exemption, and the single private landlord thing is not in and of itself an exemption. There have to be other things attached to that in order for that to occur, for that to obtain. And then in terms of the option B, the unit being in a duplex in which the owner occupies the adjacent unit, admittedly, this is a little tricky. The one thing that the hypothetical noted was that the owner used the adjacent unit as a weekend home. Now, one arguably, in order to combat this eviction would, and I think it's a good argument to make, is that the law contemplates continuous occupancy, use of the unit as a principal place of residence. Now, having said that, even within local just cause jurisdictions that have previously had this type of situation, there are owners that always routinely claim, okay, well, no, I use that as my principal place of residence, but in the facts bear out that, if they do use it at all, they might use it, maybe for a day or two during the week. So arguably, that one would not be the correct answer, but there's ambiguity insofar as it's reflective of landlord practice in regards to this, in terms of their way of trying to get around being compliant with just cause laws. C, a mere basis, the mere sale of the property itself actually is not a basis to justify eviction. Under the law, what normally happens if a landlord wishes to sell the unit, if a unit is still under contract, or if a unit, let's say that the lease has expired and they're going towards month to month, yes, if the person was not protected, all the landlord basically needed to do would be to serve them a certain no cause notice. But obviously, with this law, that's no longer the case unless the unit is exempt. And what normally happens is, if you sell the property, the lease or any property agreement, rental agreement, sort of just then gets transferred over to the new owner, and they fill in the shoes of the old owner. So that C isn't really a cognizable basis in and of itself to justify eviction under the state law. So that would mean that the correct answer is D. No state just cause do apply, and would prohibit Mr. Vaughn from evicting Maida and her family for the stated reasons. So moving on. So we're going to switch gears here and talk about the Tenant Protection Act of 2020, which was passed by the legislature in response to the housing crisis that was augmented due to COVID-19. So the important thing to remember is that this places restrictions on evictions, and specifically for rent unpaid between March 1st, 2020 and August 31st, 2020. So what that means is that tenants cannot be evicted for non-payment of rent for the above period if they returned a newly introduced hardship declaration with a newly enacted 15-day non-payment notice. And we'll talk more about what that means. This is just a general sort of outline of what the important factors are. So for the period that I've highlighted above, March 1st to August 31st of this year, this declaration, which is supposed to be attached to the notice, must be returned only one time to the landlord. So if the hardship declaration would have been returned on time, then no eviction can be filed, for non-payment of rent during this period. So in terms of the new notice requirements that I sort of alluded to, as of September the 1st, 2020, landlords must now issue a 15-day notice to pay to tenants when they fail to pay the rent. So that means that, previously the law only provided for 3-day notices to pay rent or quit. And depending on whether or not your unit was subsidized, there might be a different type of notice. But in general, for most privately owned units, you would need to issue a 3-day notice to pay rent or quit, meaning that if the person didn't pay the full rent demanded within the 3 days, then that would mean that then after the expiration of those 3 days, the landlord could go ahead and move to evict. But that is not the case anymore. At least until February 1st, 2021, the notice that is required to be served on a tenant if they are being charged with non-payment of rent is the 15-day notice to pay rent or quit. And also, in addition, this 15-day notice has to include, it has to have attached to it, a hardship declaration for tenants to return within 15 days if they have COVID-related I apologize. If they have a COVID-related financial distress. And then information about tenants' rights under AB 3088 as well. So the 15 days does not include weekends or holidays. Okay. Can everyone hear me? Hello?
Yes.
Okay, sorry. I'm having a little bit of a difficulty here. My apologies. Okay, so again, the 15 days does not include weekends or holidays. So let's talk about what constitutes a COVID related hardship. So there are several. So the first one, obviously, the most obvious one is loss of income caused by COVID-19, due to loss of job or reduced work hours. Second one, increased out-of-pocket expenses directly related to performing essential work during COVID-19. Increased expenses directly related to the health impact of COVID-19. So if you're taking care of a loved one that has COVID or whatnot, maybe due to the fact that you're caring for that individual, you may need to have reduced work hours, right? So that sort of like is a combo, because it could sort of also be tied to loss of income, but that's sort of just an example of how that could be made manifest. Also, childcare responsibilities along the same lines, or care for elderly, disabled, or sick family member. Increased costs for care described above. And any other circumstances related to the COVID-19 pandemic that have reduced your income or increased your expenses. So that would be included in the explanation that you include in the attached declaration. So what about the unpaid rent? So any rent owing between March 1st, 2020 and January 1st, 2021 is not a ground for eviction if the tenant meets the applicable requirements. The unpaid rent is converted to a consumer debt, recoverable in civil or small claims court. There's no documentation of financial distress that is required if the tenant has an annual household income of less than $100,000. And now beginning October 5th, 2020, tenants who do not return the hardship declaration can be evicted for non-payment of rent. Alameda County tenants may still enjoy separate eviction protections. However, we're going to talk about that in a second, okay? Now, we've talked about, this period beforehand, from March through April, but what about rent that is unpaid between September the 1st, 2020 and January 31st, 2021? Now, this is a little different because in the past, as I mentioned to you before with that prior period, you under state law, so long as you submitted one declaration indicating that you had COVID-19 related income loss that prevented you from paying the rent. For the rent that's due subsequent to that, for the period between September 1st, 2020 and January 31st, 2021, you have to return that declaration each month the rent is owing. And in addition to that, you pay 25% of the missed rent payments by January 31st, 2021. This is in order for you to continue to enjoy the protection. Again, this is under state law. And, we're going to talk about Alameda County provisions in a second. The declaration must be served on the landlord each month, but the 25% of the rent does not need to be paid so long as the total is paid by January 31st, 2021. If the tenant paid the 25% back, rent any remain due after January 31st, 2021 is converted to a civil debt. Even if the tenant pays nothing for September through January, so long as they return the declaration, no eviction for non-payment can be filed until February 1st, 2021. I know that's a lot, but it's important just to keep in mind that there are these requirements that tenants need to abide by. But at the same time, the reality is that an eviction for non-payment, even if they may not follow all of this, the reality is that an eviction for non-payment cannot be filed and proceeded by in court until the end of this moratorium, which is February the 1st, 2021. Now, in addition, we've talked about this before. There are new eviction protections under this law. So until February 1st, 2021, just cause is required for all evictions, and all tenants are covered, regardless of where they live or how long they have rented the unit. So no cause evictions are not permitted against any tenant at this time until February the 1st. So if a landlord files an eviction action against a tenant based on something other than non-payment of rent, also you need one needs to keep in mind this landlord can't collect rental damages due between March 2020 and January 2021. Okay, so the one thing I want to mention really briefly. So you notice this February 1st, 2021 date. It's looming over the horizon. We have less than a month and a half. So all I can say is that based on my very limited knowledge, there are certain discussions being had in the legislature about extending this in light of the fact the pandemic is only getting worse, the infection rate is worsening, due to the winter and the fact that people are, mostly staying inside more so than in the summer, along with other factors, obviously. So I wouldn't be surprised, and of course I can't, guarantee anything, but I wouldn't be surprised if there would be an extension. Obviously, that extension is going to be, very hard fought because obviously there are other interests, with respect to landlords insofar as receipt of rent monies and whatnot. But there are active discussions right now insofar as extending this, and there has been precedent for this, at least at the local level, because we have had moratoria here in several Bay Area cities that predated the state law, a moratorium. Where they put an end date, but then realizing that the pandemic was only getting worse, not getting better, and obviously the resultant economic situation obviously was also getting worse, thereby obviously causing an increase insofar as rent instability. Those moratoria were extended in various cities, so it would not be surprising. Just given what's happening, that this also may happen as well in terms of extending these protections. But right now, it is tentative; it's up in the air. So, as a sort of transition slide, so insofar as in relation to COVID-19 state law AB 3088 and how it interacts with local moratoria. So, any eviction moratoria passed by any California municipality prior to the passage of AB 3088, and which provides greater protections than those included in the state law, they are for the most part still enforceable. We don't have time to get into like what portions are. What essentially they are about the repayment of rent after the moratorium periods end. So there's an argument about whether or not state law actually prevents or basically takes precedence over the local moratorium insofar as what happens after the moratorium period is over, insofar as the payment of rent, when rent payments to the landlord can begin in order to reduce the debt. But insofar as the actual protections, I wanted to talk a little bit about the Alameda County protections, because they do seem to offer slightly more protections to our tenants in our county here in relation to evictions. So this Alameda County eviction moratorium, it serves to invalidate all eviction notices served or expiring during the moratorium period, except for allegations of imminent health and safety. So, for example, if there is a tenant who is accused of having committed a violent criminal act on the property, threatening another tenant, violating a restraining order, etc., that could potentially be cast as commission of violent of an act that endangers the imminent health and safety um, of other people around the premises. So that could potentially um, be a cause for eviction, even though there is a moratorium on evictions in effect in this county. So the other one is an Ellis Act, a removal from the rental market. But again, we've talked about before how right now, because of the state law, no cause evictions are generally invalidated at this time, at least until February the 1st. So that's just something to keep in mind. And that's again, just illustrative of the slightly complex interplay between the state and the local law. Again, to the extent that the local law provides greater protection, it will apply. But we also have this overarching state law that up until February 1st generally bans no cause evictions. So obviously you would argue that that would be controlling, at least in terms in the context of the Ellis Act. The other issue right now is pursuant to court order or government agency red tagging. So that could also be an exception under the Alameda County eviction moratorium. But unless you fall in to these exceptions under the county moratorium, the eviction wouldn't, be something that could be pursued. There are also no future evictions for rent accrued during the moratorium period if the tenant provides documentation of COVID-19 basis for non-payment. Now, this under the moratorium, and it's a little confusing, it's not exactly the same as what the state law requirement is, and we'll talk about that in a second. Insofar as the reasons for COVID-19 basis of non-payment are similar, but insofar as a provision of declaration, the Alameda County eviction moratorium doesn't necessarily require a specific format for it in order for the person to be protected under the county moratorium. But again, to the extent that there's this overarching state law, even though one would argue that one does not need to file this declaration the way the state law says in order for you to be protected in the county moratorium, in order to cover all your bases and to be on the safe side, when we advise people, it's like, okay, it's still best practice if you can to do it. The better protected you are, obviously, the more better off you and your family will be. But technically, the county eviction moratorium doesn't require the same type of declaration, standards as does the state law. So the moratorium period applies to all cities in Alameda County, and it lasts from March 24th, 2020 until February 28th, 2021, or 60 days after the local state of emergency has been lifted. And I apologize for that typo. Whichever date is later. So that's the important thing. So that's sort of what differentiates it in terms of evictions from the state law. Because the state law right now, unless it's extended, the end date is for those protections is February 1st. Whereas there's a possibility for the Alameda County eviction moratorium to extend, insofar as preventing evictions, to extend beyond that time frame. So what are the documentation? What is the documentation that one can submit regarding a COVID-related basis for non-payment? So it's in this regard, in terms of like general reasons why it does mirror, in many ways, state law insofar as a valid basis. So one of the things that you can submit is an employer letter citing COVID-19 as a reason for reduced work hours, termination, or other substantial reduction in pay. You can also submit paycheck stubs showing pay reduction after the COVID-19 lockdown, bank statements showing income reduction after the COVID-19 outbreak, any documentation showing substantial out-of-pocket medical expenses caused by COVID-19, documents showing school or childcare closures that affect work hours, and a sworn statement, which is an informal declaration, not necessarily the one that's provided by under state law, by you attesting to loss of income, including facts showing loss, and stating that you are not able to gather other documentation. And I do include the note, we've already talked about it, but just to reiterate, Alameda County residents are not required to submit the state law declaration under AB 3088 in order to be protected under the local moratorium. But out of an abundance of caution, they should still submit the state law declaration if at all feasible. And again, on a case-by-case basis, if they don't, and it ends up being the case that, the landlord's arguing because you did not submit the state law declaration, that means that, you don't enjoy the same protections. But if they're an Alameda County resident, obviously we would counter as like, no, well, there's also an overarching eviction moratorium that's county-wide. They'd still be entitled to those protections under the county ordinance so long as they complied with the county-related requirements. So in terms of provisions for unpaid rent, under the county moratorium, any rent due within the moratorium period, but that is unpaid due to reasons related to COVID-19 as defined in the ordinance, converts to a consumer debt. So a landlord may not evict a tenant in the future, even after the moratorium ends, for this consumer debt that accumulates within this period, right? The period of the moratorium. Rather, they must collect the debt through collections, limited civil or small claims court. So, okay, let's get into this hypothetical number 2 here. So Ricardo rents a studio apartment located in Hayward, California. In July of 2020, Ricardo lost his job at a bakery due to slowed business related to COVID-19. He has been unable to pay the full $1,500 monthly rental amount to the landlord. Ricardo wrote the landlord a letter explaining his circumstances and offered to pay a third of the rent until he's able to locate another job. The landlord refused to work with Ricardo and issued him a 1-page, 3-day notice to pay rent or quit, which demanded that he pay past due rent that he has accumulated from July to December 2020. No other documents were attached to the notice. Ricardo was unable to pay the rent demanded, and the 3-day notice period has now expired. So the question is, can the landlord validly move forward with evicting Ricardo based on the above facts? So I'll open up the polling again, and let's hope I do the correct one this time. Okay. We'll leave it there for a minute for people to reply.
Someone is asking if we could go back to the hypothetical.
Oh yeah, sorry, my apologies.
Sorry. No worries.
So let's see, can everyone read? Let me go back here. Here we go.
Perfect, thank you.
I'm gonna put this to the side here. Give it a few more seconds. Okay, I'm gonna close polling. So all of you are correct. I would say that the best answer here is D, all of the above. And let me go over why that is. So no, the landlord is not allowed to use the 3-day notice to pay or quit to evict a tenant for non-payment of rent. So that is obviously correct right now, because right now we now have a 15-day notice mandate that applies to any eviction for non-payment of rent. in the state of California. So the fact that in this circumstance, the landlord is trying to get him out based on a 3-day notice is invalid and can be challenged in court. Also, B is correct as well, because the landlord did fail to attach the mandatory COVID-19 declaration. Again, that's a state law requirement. Normally, when you talk about the papers that need to be included in an eviction related action, the state law requirements control generally. So there's a baseline of documentation that needs to be submitted, and to the extent that state law requires the mandatory COVID-19 declaration to be attached to the notice that the landlord is issuing, that's something that the landlord can't get away from. They need to comply with that. There's a different question as to whether or not the tenant here loses all protections if, for whatever reason, they don't submit the state law requirement. They may arguably under state law, but we also have another moratorium that may be at play here, which they may still be protected under, so long as they comply with the requirements under that moratorium. And so C also is correct. No, as Ricardo's inability to pay rent is directly linked to COVID-19. He has cognizable affirmative defenses to this eviction action under both the California and Alameda County eviction moratorium. So he lost his job as a result of decrease in business due to COVID-19, and he can make a direct connection between his job loss and income loss, and arguably can be a person that enjoys affirmative defenses under both moratorium. So in light of that, D, all the above is the best answer, but everyone obviously by default issued correct answers. So I wanted to just before I conclude and open it up for some questions, and unfortunately I do have to leave at 11 on the dot because I have another call. So I apologize if we're not going to be able to get to your questions, but very briefly, this is very important. So we have here a summary of our services, and we obviously help people in the counties that are highlighted, and our assistance is free. We do have an intake procedure that we have to engage in per our funding requirements, where we have to determine eligibility, financial eligibility, and eligibility with respect to immigration status. And we have 2 lines. So we have the general legal advice line that is for any other non-housing problem, as well as any housing problem that is outside of Alameda County. You call the 800-551-5554 number. For people who need advice in those areas: housing, DV, public benefits, health access, reentry, consumer, youth justice. But we also have a dedicated tenants rights line. That's the 888-382-3405 number for Alameda County residents. So that's the dedicated line. So if a person lives in Alameda County, they have a housing issue, that's the line that they call. And again, very briefly, last slide before we open it up for questions. So we do have an important update regarding our legal advice and tenants rights line. So our lines are closed right now and will not reopen until January 4th, 2020. This is because we have to perform key technological upgrades to our systems that will allow us to better serve clients in the new year. So during this time, if a person has a legal issue, we recommend that they use the resources at lawhelpcalifornia.org to find legal help based on their location and issue, or to call 211. And we do apologize for this, and we thank you for your patience in advance. And so just as a mode of further explanation, so without the system that we rely upon to do conflict checks and income checks, we can't, accept new cases right now, unfortunately. But come January 4th, the new system will have revved up and we'll be able to take calls and intakes at that time. Okay. So thank you. And I now want to open it up for the next 7 minutes or so for any questions.
Please feel free to unmute yourself or put your questions in the chat function. So someone asked, the legal advice line is indeed closed until January 2nd, correct?
I'm sorry, January 4th is a Monday, the Monday that will be open. Yeah,
Okay.
so January 4th.
January 4th is good.
Yeah, the 2nd is
And
a Saturday. Yeah.
okay, cool. And you will get a copy of the PowerPoint if you registered and I was able to get your name. You will get a copy of the PowerPoint. I'm gonna put my email in the chat box just in case you did not get a chance to register. I could connect with you afterwards. And someone was asking, as a protections change, what's the best way to keep up to date on the latest?
So we do try to update what we know in our website. It's www.baylegal.org. There's actually a housing tab there, and we try as best as we can to get an update on that. And then also, you can always go to the legislature's website. I don't have the link right now, but I can certainly provide it to Yadiel, and then she can possibly send it out. That sort of keeps people up to date insofar as any sort of legislative maneuvers insofar as the expansion of the COVID-19 related moratoria at the state level. Now it's a little more difficult in terms of the local moratoria, insofar as what they're allowed to extend and if they're going to extend it. It is possible that they might extend certain moratorium related provisions in Alameda County. So for that, the best way to do that to keep up to date insofar as that is to go to the Alameda County AC Gov website. They prominently feature, I think, in their homepage, updates on the local moratorium as well. So those are my suggestions, and we obviously try as best we can to keep up to date as well in order for us to be able to give advice once the line reopens. So we will certainly be doing that. All of our attorneys who handle housing related issues are keeping abreast of this as well, so that when people call, they can get the most up to date advice. But for now, for the time being, yes, at least until February 1st for the state law protections, and at least a month further out beyond that, if not more, in Alameda County.
Great, sounds good. Someone is asking if you could explain a little more on how the unpaid rent that is converted to debt is expected to be paid or received by landlords.
Okay, so if it's converted to debt, then that means, well, one of two things can happen. I mean, it all really depends on the particular relationship you have with the landlord. It could very well be the case that once a particular tenant is able to, the landlords generally run a ledger in terms of what rent is owing. I mean, if they're responsible enough, I mean, that's assuming that's the case, but they have a running ledger insofar as what rent has accumulated. And if they have a good relationship with the tenant, they could in fact enter into some sort of payment plan where, in addition to the rent that becomes owing after the moratoria is completed or over, then they would possibly give a certain amount of money in terms of the back rent that was owed during the moratorium period, that is covered and protected in the moratorium period. So if for whatever reason that breaks down and the landlord, and the tenant don't agree, then at that point in time, the landlord can sue the tenant in small claims court, or if the debt is higher than $10,000, can go to Superior Court to try to recover that money through a civil lawsuit. But if it's rent that is covered under the moratorium periods, then the landlord can't evict the person for not having paid that rent if it was rent that accrued during the time periods in question. So their only mechanism, if things break down between them and the tenant is to try to recover it based on whatever ledger they have through the small claims or superior court process.
Makes sense. So we probably have time for one more question. Good.
Well, if there are no more questions, I'd like to thank you all for participating in this training. I do have to go, but I do wish all of you a happy and safe holiday season.
Thank you so much, Jesus. Thank you.
Thank you.
Appreciate it.